Welcome back, everyone. It's Peter Tragos, the lawyer you know, and today we're going to talk more about the Chandler Halderson trial. We all know we're in week 3 technically, but only week 2 of the trial because of the week break when the defendant got COVID. We've picked a jury, we've heard opening statements, and we've heard from quite a few witnesses. There have been a ton of witnesses that have gotten on and off the stand within 5 or 10 minutes, just coming to prove one point, and I think the state is absolutely setting this case up perfectly, one right after the other. They made statements in opening statement that Chandler did this, but this is actually the truth, and then they come and have someone testify that Chandler said this, and then they have someone else come and testify and say that this is actually the truth. For example, one of Chandler's friends came up and testified that he said he was on the police scuba force, and then he had the assistant chief of police come and testify and say, we don't have a police scuba team. And I've never heard of Chandler Halderson before this case, and he was never employed or a volunteer with my police department. So just like that, where they would have back-to-back witnesses real quick come up just to prove he's a liar at this point here and there. They've also had a lot of testimony as to where they found body parts. Medical examiners testified, a lot of law enforcement officers have testified, and we're going to talk a little bit about that testimony today. But most of the questions from you, and what I'm trying to bring to the table in this case, because I know there are a lot of people and a lot of lawyers talking about this case and breaking down this case, my focus is going to be on what the defense attorneys are doing. Are they doing enough? Are they trying? Whether or not they believe their client's guilty, whether or not they like their client. There's a different dynamic with public defenders. People always ask me because they don't get to choose their clients like I do as a private criminal defense lawyer. I can say no to a client if I want to for whatever reason I want to. They don't necessarily have those same opportunities to do that as a public defender, and the same thing the other way around. The defendant doesn't necessarily look at all the attorneys in the world and say, I want you to represent me, like they may be able to do in the private sector. So there is a little bit of a different dynamic there. I don't think that's what's happening here, that they're just not trying, but I don't necessarily think they are doing enough to provide an adequate defense for him. We talked about why in opening statements, and now we're going to talk why as we go through some of the witness testimony that's been heard up to this point. I haven't been watching every second of this trial. I haven't seen every single witness, but I've seen a ton of them. And I have a lot of information to talk through just as a criminal defense lawyer. What I would do in a situation like this where you feel like you're going to lose, your back's against the wall, there's a mountain of evidence against you, but you've picked a defense. How can you attack these witnesses and trying to continue to build your defense? That's what we're going to talk about today. That's the content I'm going to try to provide around this case. Hopefully you guys enjoy that. It seems like that's what you want from the comments, and you can let me know if this is the kind of content you want by liking the video and continuing to comment your questions as opposed to just a general recap. This witness came up, they said this. This witness came up, they said this. Doing this one a little bit differently to put you in the mind of a criminal defense lawyer. And when even you, who are not lawyers, lay people out there watching this trial, are asking me, what are they doing? Why aren't they asking any questions? Are they doing this on purpose? We've all heard that criminal defense lawyers and criminal defendants don't have a burden. They could sit there and twiddle their thumbs. They could play thumb war at defense table the whole trial, and that would be fine because they don't have a burden. Well, that's just something we say to juries. We don't actually do that. We don't actually do nothing in most cases. Very rare circumstances, we would not have to ask any questions because our case was that good. But we don't actually just say no thank you every time the judge asks if we want to cross-examine a witness, which I have heard way too many times in this case. So I'm not condemning these defense lawyers. I'm not saying they're horrible lawyers. I'm just saying there are some things I would do different in the defense of Chandler Halderson, and that's what I want to talk about through these videos. So we get our content from you. This is the content I think you want to hear. So let's get to it. The first witness I want to talk about is Mitchell, Chandler's brother. He comes up and testifies for a very simple reason, and I also really like, because if I'm a juror, I know exactly why the state is bringing this witness. I know exactly the details the state's trying to get out of this witness, and I feel like they've done a great job of doing that. Better than Binger did in Rittenhouse. Sometimes he called witnesses, and I'm like, why did he call this witness? I don't understand. In this case, they call the brother. The brother talks a little bit about Chandler, a little bit about his parents. They get some sympathy factor, talk about how his parents go to the cabin sometimes. But the big reason they called the brother, in my estimation, is Chandler and the brother are beneficiaries on at least $1 million worth of life insurance policies. And that's not including some other assets they may have, like the house and the cabin. They are the beneficiaries. Chandler, the defendant, stands to gain a monetary value if the parents were deceased. Cross-examination. At least there was cross on this witness, and they asked, well, you didn't go to the cabin that often. Isn't it true your parents would turn off the phone once in a while, which I think is a good point. You go to a remote cabin, cell service isn't that good. Sometimes they turn off the phone for roaming charges. That was a good piece that they got out. And then they impeached him about when he started to be concerned about his parents, which again, this is something that you don't want to ask multiple questions about. Your parents were killed by your brother. When did you become concerned? Well, you told the officer you became concerned another day. Are they trying to implicate him in the murders? Because nobody's pointing the finger at him at this point, but maybe they're trying to say, give the jury somebody else to point to. You're a beneficiary. Maybe you had the same opportunity Chandler did. I don't think it would be a horrible angle to take, but they didn't develop it at all throughout the case. So to just kind of impeach him on that, I didn't think was great, and I actually think made me feel sorry for him, which is not what they were going for. So what would I have asked? In addition to that, it was a very short cross. I'm going to give you some of this and you're going to catch a theme and you're going to understand. And by the time we get to the fifth witness, you're going to know what I would have stood up and asked that witness. And that's purposeful. I want the jury to understand what my angle would be. So we're starting from the place of they have made it clear, their defense is, there's not enough evidence to convict Chandler Halderson. There is a gap in evidence. Nobody knows what actually happened for a period of time. We have some stuff before, we have some stuff after, we have some lies that don't matter, but we don't actually have evidence of what happened in the murder. Is it a good defense? I don't know, but that's the defense that I'm going to put in my head as I'm trying to figure out what we can get out of these witnesses, and sometimes it's not going to be very strong. Sometimes a witness is going to hurt you, sometimes you're not going to have much to ask. And the brother's one of them. You don't want to hammer on the brother, right? He's a grieving son. But you could at least ask, were you there the day of the murders? Were you at the house? Were you at the cabin? Did you talk to your parents before or after? Did you see any indication that your brother did this? Has your brother hurt anybody in the past? Have you ever gotten in a physical altercation with your parents? Have you ever gotten in a physical altercation with your brother? Have you ever seen your brother fight your parents before? You can at least ask those questions, assuming you know the answers, but you can at least ask those questions to make it seem like, well, maybe Chandler didn't do this. He never did anything like this in the past. And what does his brother actually know? He didn't witness anything. Let the jury understand that everybody that comes up and testifies did not witness the murder. That's an important factor I want to get across with every single witness. You didn't witness what actually happened, right? Because you weren't there that day, right? Okay, now let's talk about Chandler for a second. Never fought your parents before. Never fought you. Never hurt anybody in the past. Never used weapons against anybody in the past, right? At least it's something. Then we have one of the friends of the parents, somebody who worked with Chandler's mom. It's very unlike her to miss work, and the cross was, would you consider yourself close? Would you consider yourself a friend? Getting bias. Fine. That's something you can use on every witness. You're a friend of the family, so you want to come here and do what's right for them. Works a lot better in civil cases when the plaintiff is trying to get money rather than a victim in a murder case. Yes, I was close to her. That's why I'm grieving, because I lost my friend. It doesn't necessarily show, oh, he's probably going to take the stand and lie. It doesn't help his deceased friend if he takes the stand and lies to try to convict her son. If anything, it would be worse for him to help convict her son if he didn't do it. So if he wanted to help her, he wouldn't lie about her son. So again, I don't think that was that strong. Again, very simply, I would get up and ask him, you didn't witness the murder, right? You don't know how any of this happened. You just know she didn't show up for work, right? You didn't see the bodies, you didn't see the murder weapons, you didn't see any of that. Just ask them so the jury realizes, at least maybe the jury will think these witnesses are less significant than they seem at this point when you're asking no cross. Because it is true, they didn't witness it. And if that's enough reasonable doubt for this jury, then you win. John Ponelt, I don't know how to pronounce half these people's names, but this is basically the guy that owned the convenience store, testified to the video. And he says, yeah, here's the video, here's Chandler carrying some ice. No thank you when the judge asked if the defense attorneys wanted to cross him.
Anything from the defense?
Nothing, thank you.
All right.
No thank you. Okay? Well, even if it's very short, I get up and I ask him, sir, anybody else buy ice that day? Anybody buy ice today? Do people buy 2 bags of ice all the time? Do you see people carrying ice throughout your store literally every single day? Does that mean they committed murder? Did you witness the defendant commit murder? Do you know if the defendant committed murder? Do you see him with any murder weapons in your store? Something. I mean, at least for the jury to be like, yeah, what does the fact that he had ice really prove? The state's making arguments to connect it, but we're not actually hearing evidence that he put his parents on ice. from this guy at least. So just make the witness less significant. That's all. Don't let the prosecutor connect these dots so easily. All right, let's talk about Zach Reed, the HVAC guy who had an appointment to come give an estimate, showed up, Chandler showed up to talk to him. By the way, throughout all of the witnesses I've watched, I have counted exactly 0 objections. Now, it's possible I missed them, and you can correct me in the comments, as I'm sure you will do, because you guys love to do that, and I love when you do that. I have heard 0 objections. So if Halderson is planning on appealing for anything, he's going to waive appellate issues that his lawyers do not object to. That is the most damning action. The cross-examination, the weak opening, whatever it may be, that doesn't kill you as much as your lawyers not protecting the record. Object when they ask leading questions. Object when they basically tell a witness what to say, they being the prosecutor, in their direct examination. Object when a witness speculates. Object when a witness talks about something that's outside the scope of their knowledge, which has happened a ton throughout this trial. Witnesses are guessing or saying, I think this or I think that. That's speculation. You can't do that. You can talk about your observations of what Chandler looked like, but you can't say, oh, I think he was acting like this, or I think he was doing it because of this. That's pure speculation. They can't testify to that. That's not evidence. That's not reliable. So Zach Reed, he did some of that, and there were no objections. He described his demeanor and how he was acting and why he was acting. Now again, observations, he was sweating, he was coughing, he wasn't making sense. That's fine. Then, describe anything unusual or noteworthy, and he answers the question. Dryer vent taped shut. But that's not the answer the prosecutor wanted. So the prosecutor takes a step further and gives him the answer in the question. What about the windows? Anything unusual about that? Objection, Judge. The question was asked and answered. Now he's leading the witness to give him an answer that he wants. Object. Now, even if that objection is sustained, you can ask some other question, as any decent lawyer would, to get the answer that you want, but at least try, right? That's what a lot of you are asking for. At least try. So, didn't ask him any question about, or didn't object. They asked, the windows were all open. I thought that was weird. The defense lawyer says, well, it was a hot day, right? Maybe that's why the windows were open. So, I don't think the jury's going to convict him because the windows were open, right? So as opposed to saying, oh, it was a hot day, so it was reasonable for him to have the windows open, I assume the prosecutors are going to argue the windows were open because the smell of the dead body was so bad he didn't want to leave all of the windows closed. So why don't you ask the HVAC guy on cross, which they didn't do. I mean, I didn't think this was her worst cross because she did ask some questions about how do you know it was Bart that made the request and not the person that you came and talked to. It was hot outside. Doesn't know what the house normally looks like. Maybe it always has tape over the dryer vent. Maybe the windows are always open. So I thought she did get some good points across. But why not ask? You went to the house. You walked all the way up to the door. You were close enough to see the windows were open. Did you smell a dead body? Did you see any blood? Did you see any body parts anywhere? Was there any blood on Chandler when you saw him? Why not ask those questions? Because his answer is going to be no to all of that. Because why would he see any of that? And I mean, if he didn't smell the dead body, actually that is some evidence. So if you're going to argue the windows are open because of the smell of the dead bodies, he didn't smell any dead bodies outside with the windows open, so maybe there were no dead bodies in there. Ask the questions, at least get the jury thinking. Give them, if they're looking for reasonable doubt, give them something to look for. Then we have Hilge, one of the friends that's talked about, who said he went up to the cabin. It was obvious nobody had been there for some time. There was a log in the road. The grass was high. And cross-examination was, well, you didn't really hang out with them as much as you thought because they moved to Plymouth. You didn't meet with them as regularly. You saw them less. Didn't you find a shell casing? And here's what they try to do. Sometimes defense lawyers try to get their client's statements out without their client testifying. And it's technically objection because it's hearsay. The prosecution can have other people testify to what the defendant says because that's an exception to hearsay because it's a statement made by a party opponent. But you can't tell people to say what your client said or say, my client told you this, didn't he? Because your client is not a party opponent. It is your party, your client. Confusing. But she tried to get a statement out saying, wasn't there a shell casing at the cabin? Which I think is a good point if there was. I think that gives the jury something to think about since the father was shot. And he said, no, there wasn't. And she said, didn't you tell Chandler Halderson on the phone that there was a shell casing, which is just basically saying Chandler Halderson says you told him there was a shell casing at the cabin. And the witness says no. And that was basically it. And then there were a lot of witnesses who talked about pictures and locations and the weapons that were used and how the bodies were taken apart and how you could tell based on the jagged edges, and there was virtually no cross-examination throughout. There was no objections. The no thank you that I heard so many times when the judge asked if you want to cross this witness was amazing to me. I couldn't believe it. At least ask those people, you didn't witness the murder, right? Even though you can tell how the body was dismembered. Let's talk about the one of the medical examiners at least. She talks for an hour about what happens and about how these people died and how they could tell it was their body and how you could tell whether it was a saw or a knife with a straight cut or a jagged cut, and how these body parts were identified and how they connected this body part with this person. No cross at all. At least ask. Okay, so just to be clear, all you're testifying to is that these bodies are the Halderson parents, right? You're not testifying to who did it, where it was done, if Chandler was there, if Chandler had anything to do with it. You don't know, right? Your exam can't say that. I don't think, and I'm not positive, remember, I don't think they found like Chandler's fingerprints on the bodies. I know they found some of the parents' blood on some of other belongings, like a tarp and Chandler's shoes, but at least you can ask the medical examiner, when you looked at these bodies, you didn't have any of Chandler's fingerprints, none of his hairs, nothing like that on the bodies. And if I'm misremembering part of that, I apologize. But at least get up and ask her something like that, and talk about how she didn't witness what happened. She doesn't know who did it, she just knows how it was done. Because I think that's important to minimize that testimony to the jury. While yes, this is gruesome and this is horrible and the jury has to listen and see these horrible pictures, but just because this happened to his parents does not mean he did it. And I think that's important. Especially when our opening is don't make assumptions, don't make guesses, don't jump to conclusions. There's a lack of evidence. Talk about where that lack of evidence is every chance you get. And I was interested in Andrew Smith as a witness, as a lot of you were, and you talked about it in the live, how you wanted to hear what I thought of his testimony. It was exactly as I expected. Curt, yes sir, no ma'am, wanting to be a weapons big shot, not wanting to answer certain questions, basically there to protect his own tail, which he didn't make any qualms about. He basically said, I took this picture with this ID and serial number to make sure that if something like this happens, I wasn't going to get screwed. He used more of an expletive. But he was honest, straightforward, talked about how he knew Chandler, he gave him the gun, talked about why he didn't want the gun anymore. Now listen, there are going to be some jurors that do not like this guy at all. And they're going to say, why are you just giving people guns? That's weird. You go through this whole process where you fill out all this paperwork, but you don't make them do any of that. You don't do any background checks. You could be giving dangerous people guns, obviously. So I don't think he's going to be the jury's favorite witness, but he was just there to clear his own tail, and the state got the fact that he gave Chandler the gun. It was Chandler's gun. That is the serial number, and that was the gun that was used. Now on cross, how loud would the gun be? How loud would the shot be? I assume they're setting up that somebody would have heard it if Chandler pulled the trigger. But they got into a weird argument about whether you could put a silencer on that gun and what it would sound like, whether it's louder or softer than a handgun, and what environment you use it in, outside or in a small space, how loud would it be? So some weird stuff like that I'm saying is confusing, right? And there's no need for that. You want to just get in and get out and get the points across that you know. And if you don't know the answer, don't ask the question. And don't argue with the witness. And then she asked, you've gifted and sold other firearms, about how many? And he said, it's none of your business. And then she's basically like, okay, nothing further. It just seemed like she took a shot and then went down. She didn't fight back. I would have pushed back at least. If he's going to disrespect me like that, I would have been like, well, are you selling guns to anybody else that's committed crimes or been accused of crimes? Are you selling guns to everybody? Are you just giving guns to all your friends? Do you think that's a good idea? At least ask some questions. At least point to the jury that this guy not making smart decisions. So at least make the jury think, well, maybe we can't believe this guy. Maybe he's a little shady, whatever it may be, because he didn't come off as the most well thought out person as far as who he's giving guns to, at least. And then he did talk a lot about the first person shooter games. He explained what those were, how he played those with Chandler. So on cross, I would have at least dug into that a little bit and said, so you play, he called them FPS games. So you play FPS games, right? You know a lot of people that play them. You have a lot of friends that play them, right? Does that make you a murderer? If you play FPS games, are you a murderer? Are all your friends murderers that play FPS games? Do you do what you do in those FPS games and outside in real life for fun? Do you go shoot people in real life like you do in the FPS games? Because he's going to say no, because if we know one thing about this witness, he's there to save his own skin. So if she would have asked those questions, he would have said no. No, I'm not a murderer. No, all my friends aren't murderers. No, everybody that plays these games are not murderers. I think, and he wasn't expounding. He wasn't trying to bury Chandler, I didn't think. He was just answering the questions, right? He want anything about him, though, he was going to fight back and get defensive. But from my perspective as the defense lawyer, I would have at least gotten to the fact that let's lessen the blow, especially in opening. We all remember he's a 23-year-old kid that likes to play video games. Well, make it seem like it's normal to play these video games, and you've got a kid up here right now, or a man up here right now who plays a lot of video games. He doesn't think there's anything wrong with it. Let's talk in front of the jury about how there's nothing wrong with playing these video games, how it doesn't make you a murderer, normalize it, because that's true. Playing that video game does not make you a murderer. No matter what you feel about those video games, and maybe people that have certain tendencies like those games more, that's fine. We can talk about those studies. But that fact alone, that you play first-person shooters, does not make you a murderer. I would at least make that point clear as I'm going through this witness and at least get something out of this witness. Dakota Brown, another friend, no cross. Paige Valenta, the assistant chief of operations, who testified that, I think Dakota Brown testified that he said, no, actually that was a different friend, that he said he was in the scuba team on the police officer or the police force, and then Valenta said he's not there. We don't have a scuba team, no cross. I would at least get up and ask those witnesses, you didn't witness the murder, right? You don't know anything about this murder, right? You didn't see the bodies, you didn't see the weapons, you didn't see anything that happened, right? At least get them to testify that they are not testifying about this murder. The state is putting on all this evidence about all this other stuff that is not the murder just to try to make him look like a bad guy. If I'm going to argue that in closing, where she said you're going to hear about stuff before and after, but not the actual murder and what happened, then I have to get out the fact that none of these witnesses can testify to where I think there is a gap in evidence or where I think there is no evidence. So while it may seem repetitive, I'm still going to get up and say, you didn't witness this murder, right? All the law enforcement officers that did the investigations and did the searches and found this stuff, you didn't witness a murder, right? You don't know how he got that phone, do you? You don't know how he used that phone, do you? At least ask those questions and talk about what they don't know. There was one officer where she did finally, on cross, point out how he didn't use as good of a technique or as in-depth of a technique when looking at these videos or pictures as he did on another one. The officer argued with her a little bit and she just backed down. She didn't pick apart any of the police investigation, anything that could have possibly been done wrong, anything they could have missed, anything they took too long to do, anything that had gaps that she talked about before. You've got to talk about that. And it's impossible for me to know those questions because I didn't look through all the police reports. I didn't look through all the pictures. I didn't see how the investigations were done. I didn't do the depositions of these officers to see where they cut corners, see where they jump to conclusions, especially if you're asking the jury not to jump to conclusions. Say, don't jump to conclusions like the officer did. Once they had their suspect, they were going to make sure he was convicted. They didn't look at anybody else. They didn't look at Mitchell. They didn't look at the friend. They didn't look at who they went to the cabin with. They never even tried to figure out who they went to the cabin with. Once they found out Chandler lied about going to school or lied about having a job, it was him, and they were going to make sure they put everything on him. Yet they had no witnesses to the crime. They have nothing connecting him to this or whatever it may be. Listen, there's not a ton to work with, okay? But I'm just saying, the fact that they don't go into the investigation, how they did the investigation, who they interviewed, whether or not they had any other suspects, whether they did a full, thorough investigation, those questions just weren't asked to the police officers. Now, I'm not saying that's right for every case, but at least something somewhere about the investigation to at least protect the record, or if anything should come up later, they have those answers from the law enforcement officers. I am very surprised at the lack of objections and the lack of cross-examination of these witnesses. Now, there are some witnesses we don't cross-examine, and there are some that we cross-examine very briefly. But if you were to watch us throughout a whole trial, you would be shocked at how many sidebars we have because we want to stop them from asking things that are improper, and we want to protect the record, and we want to ask for mistrials if they do something wrong, and we want to object. A lot of this can happen before the trial on motions in limine, saying these witnesses can't testify to these things, so I don't want them to be allowed to be asked any of these questions. Object when something improper happens. Object when somebody's testifying unreliably. You have to protect that record. You have to let the jury know this is not proper. You have to keep things from the jury that they shouldn't hear because witnesses should not be allowed to speculate. And I'm sure there's going to be some people that disagree with me and just think every witness should be able to take the stand and say whatever they want to say. But there are rules of evidence, and those rules have to be followed. And you as the defense lawyer a lot of times, or sometimes the prosecutor, have to enforce those rules. You have to make your objections. You have to call attention to it and make the judge make a call. You have to protect the record. So far, I'm not seeing a lot of fight out of the defense. I hope they start to cross-examine more of these witnesses. I hope that they try to get some of their points across and point out the lack of evidence or gaps in evidence if that's going to be their defense. Because I don't have a lot of hope for their case in chief. A lot of people are saying, I can't wait to see what the defense puts on for their case in chief. I do not have a lot of hope at this point. I think there are some details or at least some themes that they can push through these prosecution witnesses that they have not done. So let me know if you think, just let me know, and you can be honest. Let me know if you think that my type of questions of you weren't there, you didn't actually witness it, pointing out the gaps, pointing out the lack of knowledge, pointing out the fact that these witnesses are testifying to things that have nothing to do with the murder, would that help at all? Or does he still get convicted? And if he does, is it at least a better defense? Let me know, because that's really all I see that this defense attorney team could do differently. Let me know if you've thought of some other things you think they could do that would work on you as a juror, because while you may not be a criminal defense lawyer, you are a potential juror. And you are the person that has to be convinced one way or the other beyond a reasonable doubt of what happened. And you are the one that has a vote at the end of the case. So let me know what you think. Let me know what you think would make the difference. And as always, put in the comments what you want to hear as far as my angle for this trial going forward. But for now, that's all we've got. Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.